Welcome to the class of Conveyancing Law and Practice, a unit taught in Year 4, Semester 1. My name is Dennis Kiora. Today we're going to look at topic number 5, which is known as the completion stage of conveyancing. It's important to understand that this particular stage is the one that comes immediately after the contractual stage of conveyancing. And there is generally no accepted meaning of completion, basically because it varies from one transactional scenario to another. So completion as a process will mean a number of things, different things, depending on the nature of the transaction. But according to the LSK conditions of sale, completion means the act of completing the sale of the property for a consideration. And under those conditions, that completion then could mean any of the following things. It could mean all these things either jointly or separately. It could mean the process of transferring by registration or otherwise of the interest or the estate in the property to the purchaser. It could also mean the granting of legal possession to the purchaser. It could also mean or even include the settlement of utility bills and utility accounts, the transfer of utility accounts. It could also mean apportionment of outgoings between the vendor and the purchaser. And the outgoings here, we are talking about things like rents and rates. Now, in the process of completion, there will typically be a clause in the sale agreement that talks about completion. In that agreement, there will be a stipulation known as a completion date. And the requirement or the expectation in law is that on or before this date, then completion should take place. Unless otherwise agreed between the parties, the LSK conditions of sale envisage that completion should take place within 90 days from the date of execution of the agreement. Like I had said in relation to the contractual stage of conveyancing, the completion clause should be constructed very carefully, and a huge percentage of the disputes that arise in the process of conveyancing arise within the process or in the process of completion. But largely, what happens in the process of completion? On completion, we expect that the purchaser should pay the balance of the purchase price. And to enable the purchaser to transfer the interest in land to himself or herself, we expect that the vendor should hand over the documents, usually referred to as completion documents, to enable the purchaser transfer the interest in land in their favor. But then again, the structure of the completion clause and even the process of completion itself will also depend on the circumstances of sale. For instance, if it is agreeable to the parties, it is possible that a professional undertaking can be issued by the purchaser or the financier's advocates to secure the balance of the purchase price in exchange of the completion documents. Now, this requires careful consideration. This also envisages a situation, it envisages a situation where the process is financed, the purchase is financed. So if the purchase is financed, it is possible that the advocates of the financier will give a professional undertaking to the advocates of the vendor, usually to the effect that upon transfer of the property in favor of the purchaser and a charge in favor of the financier, then the balance of the purchase price shall be paid. Now, if the professional undertaking is the one that is moving, if the professional undertaking is in respect of a cash process, then the advocate of the purchaser can give a professional undertaking to the advocate of the vendor, usually to the effect that the advocate of the vendor can produce the completion documents to the advocate of the purchaser, and that within a certain period after the transfer of the property in favor of the purchaser, then the balance of the purchase price shall be paid. It is very important that when an advocate is giving a professional undertaking, and as the name suggests, this undertaking only moves between professionals. In this case, it only moves between advocates. In fact, in the event of a breach of a professional undertaking, an advocate takes a personal responsibility. It is therefore important that before you give a professional undertaking, and even by the expectation of the law of conveyancing, the advocate of the purchaser should actually have this money in the client account. Because remember, if this money is not available at the time when the undertaking should be fulfilled, then the advocate will take a personal responsibility. Now, for purposes of the venue and the time of completion, it is notable that the venue should be in the vendor's advocate's office unless otherwise agreed. And on completion, the parties to the sale transaction have to comply with the obligations which are varied. Now, I want us then to look at the obligations of the various parties in the process of completion, because it is the violation of these obligations that brings about disputes. Now, the purchaser's obligations is mainly the payment of the balance of the purchase price. That is the major obligation of the purchaser. And usually the requirement is that the balance of the purchase price should be paid to the vendor's advocates, to the vendor's advocate's bank account, typically by way of RTGS, about 3 business days before the date of the completion. This means that by the time of the date of the completion, this money should have been cleared and should have reflected into the vendor's advocate's bank account. And this then will be able to facilitate the execution of the documents, because if this is not the position, if these funds have not been cleared into the vendor's advocate's bank account, then the vendor may have no reason to sign, to release the completion documents. Like I've just explained, it is possible that the balance of the purchase price can be secured by way of a professional undertaking by the advocates of the vendor to the advocates of the advocates of the seller, the advocates of the purchaser to the advocates of the seller. And therefore, if it is agreeable, an irrevocable professional undertaking can be given by the purchaser's advocates or the financier's advocates to the vendor's advocates to secure the payment of the balance of the purchase price upon registration in favor of the purchaser. Now, when you are constructing the completion clause and when you are maneuvering this area of completion, advocates must understand that the interest of the purchaser and the interest of the vendor are typically at cross purpose. Both of these parties have got various but varied risks that they face. The purchaser faces the risk of giving money and yet not get the property. The vendor faces the risk of transferring the property and yet not get the money. And that is where the area of completion becomes complex, and that is how it has to be steered very carefully. And the advocates involved, therefore, must come up with a completion process that secures both of these interests that are commonly at crossroad. The purchaser must get the property and the vendor must get his money. How you will safely steer through those conflicting interests will largely inform how the completion clause will be constructed. It is as a result of those conflicting interests that the process of completion and the construction of the consideration and the completion clause becomes very, very critical in the conveyancing process. So we have seen the two broad obligations of the purchaser, namely the payment of the balance of the purchase price and, if agreeable, a production of a professional undertaking to the advocates of the vendor, in exchange of which then the completion documents can be produced. It is also possible that the advocates of the vendor can be themselves to give a professional undertaking, particularly where the balance of the purchase price has been paid in full, merely in exchange of the completion documents. The advocate of the vendor can give a professional undertaking to the effect that the monies paid shall be held by the advocates of the vendor as a stakeholder until such a time when the property is securely and safely transferred to the purchaser, and the advocate of the purchaser has given a formal advice to the advocate of the vendor to that effect. Again, the whole idea is to protect, is to ensure that the risks involved in a conveyancing process are minimized so that the purchaser gets his land and the seller gets his money. Now, the vendor's obligations, on the other hand, we can almost say that the obligation of the vendor is just one, to produce the completion documents. Of course, these completion documents are many, as you can see. The original title, the executed transfer in triplicate, a valid rates clearance certificate, usually just valid for at least 21 days, together with the original payment receipts, the original land rent clearance certificate, together with the receipts, any copies of the utility bills, and utility bills here we're talking about things like water and electricity, the vendor's identification documents, the vendor's KRA PIN, 3 colored passport size photographs of the vendor, and if the vendor is a company, again, the vendor's certificate of incorporation, copies of identification documents, and usually here we're talking about the certificate of incorporation, the passport photos and KRA pins of KRA pin certificates of the directors of the vendor. That is in a case where the vendor is a company. Consents, any consents that could be required. We shall see what some of the consents that could be required in some of the consents that could be required. We are talking about things like the spousal consent, consent of the National Land Commission, consent of the county governments, the Land Control Board, even certain other documents like a discharge of charge or withdrawals of cautions if a property was a subject of things like cautions, restrictions and charges and such like things. So the major obligation of the vendor really is to assemble the completion documents. Now, but there are important things that we need to also look at in the process of completion. I want us to look at the issue of clearances. Remember, as an advocate, you could be representing the seller, you could be representing the buyer. and the obligations assigned to each of these parties. As an advocate, it is your business to facilitate and to professionally assist your client, whether it's the seller or the buyer, to be able to steer through these processes, to get these clearances. Now, for purposes of clearances, the vendor is supposed to obtain a land rate clearance certificate and a land rent clearance certificate for leasehold properties. In relation to rates clearance certificate, this typically will be given by the county government, previously local authorities. Rates, these are charges that are normally paid in respect of leasehold properties, and they are normally payable to the county governments. Remember, these are not normally registered in a title, and it's important that you are able to find out the rates that are payable against a particular leasehold property. We have had a particular development. If you look at Section 38, Subsection 1 of the LRA of 2012, this is the one that would typically require that the registrar shall not register a transfer unless a written statement by the relevant government agency, in our case the county government, has given a rates clearance certificate. I want to clarify that this particular area of law has been repealed. I will explain shortly where we are right now, because this is a development of the month of March, year 2020. It's a very, very recent development. Again, a rent clearance certificate would be required, and this is normally issued by the national government as proof that the owner of the property, in this case the vendor, has cleared any rent that is payable on the property. Again, I also wish to clarify that this is a provision of Section 39, Subsection 1, but it has subsequently been repealed, and let me just explain that. Now, by virtue of the Business Laws Amendment Act of 2020, the requirements for a land rate and rent clearance certificates have been repealed. It is no longer a legal requirement, and the registrar will not require you to have these land rate and land rent clearance certificates for purposes of effecting transfer. But as a buyer, it is your business and your duty to ensure that the vendor has got these certificates, because should you buy a property with these clearances having not been effected, what that means is that you will then acquire the property, and the obligation, these liabilities will be transferred to you. It will then be your duty. You would basically have taken over these liabilities, and it will be your duty to pay them off at the required time. And therefore, we are saying, it is therefore upon the parties to agree on the issue of rates and rent, and the buyer may insist on the production of the rates and rent clearance certificates as completion documents. I would myself advise, unless if you have got a clear agreement and clear arrangement, that you insist that the seller obtains a land rate and a land rent clearance certificate. It is therefore possible for the parties to agree that the buyer takes over those liabilities, and where the transfer is effected, the parties having not clearly agreed on the rates and rent, and the same having not been cleared, then automatically the buyer will inherit these liabilities. Remember, this is a development of the Business Laws Amendment Act of 2020 that has, for purposes of making ease of doing business, for purposes of achieving ease of doing business, have repealed these requirements. But remember, as a buyer, it is your duty to insist that the seller obtains these clearance certificates Otherwise, you will, when you buy this property without these clearances, you will then have inherited these liabilities and it will be upon you to clear them. There is also the issue of consents. Transactions in land require certain consents before the documents relating thereto can be registered. And I therefore want us to go through some of the typical consents that you will need to obtain as a seller, and you will need to insist that they be in place as a buyer. The first consent is what we call the consent of the Land Control Board. Now, this particular consent is normally required in respect of controlled transactions in agricultural land. The Land Control Board, any transaction of an interest in land, and the land being an agricultural land, such a transaction cannot be effected without the consent of the Land Control Board. Remember, this has not been repealed by the law. It remains as it were, and even under the current law, you will be required to obtain a consent of the Land Control Board. Now, agricultural land then has also been defined under the Land Control Act to mean this kind of properties, and mainly these are the lands that we find within towns, within municipalities. Lands that are outside of these areas are what are considered to amount to agricultural land. If you look at Section 3, the minister can, by notice in the Gazette, apply this act to declare a particular land to be agricultural. And the land control boards that we are talking about are at 3 levels. First of all, there is the Land Control Board that we normally find at the district level. This is the one that you obtain the consent from. There is also what we call the Provincial Land Control Appeals Board. If you are dissatisfied with the decision of the Land Control Board, you can appeal to the Provincial Land Control Appeals Board. And if you are dissatisfied with the Provincial Land Control Appeals Board, you can appeal to the Central Land Control Appeals Board. Please note that under the provision of Section 6, subsection 1, it lists the transactions which require the LCB consent, and failure to obtain this consent would render a particular transaction null and void. It is not just a sale that requires the consent of the Land Control Board. Certain other dispositions of land, things like sale, a transfer, lease, or mortgages, partitions, exchange, or other disposal of or dealing in any agricultural land situated within a land control area will require that the consent of the LCB be obtained. Division of agricultural land into 2 or more parcels also would require that this particular consent be obtained. Again, we have also said that sale, transfer, mortgage, or any other disposition or dealing either with a private company or even a corporate society would also require that a consent be obtained. There are certain situations that are under Section 6, subsection 2, a declaration of trust of agricultural land would also require consent. But there are some instances when the consent of the LCB will not be required. For instance, transmissions of agricultural land, whether by testate or intestate succession, this is about successions. Unless if that transmission would result in subdivision, if it is basically an express transmission, then it doesn't require the consent of the Land Control Board. Also, transactions to which the government is a party or which involve trust land, they also do not require the consent of the Land Control Board. So how do you obtain this consent of the Land Control Board? there are two steps. One, you basically make an application. You make an application to the Land Control Board through the appropriate lands office. And the application usually is a prescribed form, form number 1. And once this consent has been issued, you'll be given a letter of consent, usually in form number 2. Again, it is also a standard form prescribed by the law. Interestingly, the law requires that the application for consent should be made within 6 months from the time of making the agreement for sale of, the agreement for the controlled transaction. But the courts, for sufficient reason, can extend this period. I think I've already mentioned this, that in the event that you are dissatisfied with the decision of the Land Control Board, you basically appeal to the Provincial Land Control Appeals Board. And if again you are dissatisfied with the Provincial Provincial Control Appeals Board, you can appeal to the Central Land Control Appeals Board. And usually the decision of this board is considered in law to be final, and it cannot be questioned in any court. But then again, this would not exclude the possibility of challenging such an administrative decision by way of a judicial review. There are some of the reasons that the Land Control Board can refuse to give consent. You can see some of these reasons. For example, where the person to whom the land is to be disposed of is not likely to make a proper use of the land. If you're talking about issues to do with companies, where the terms and conditions of the transaction are markedly very unfair or disadvantageous to the parties, and in the case of subdivision, where the subdivisions are basically maybe too small to the extent that they can be considered to be unproductive, the Land Control Board could reject that kind of an application. And subsection 1C, where the person intending to acquire the land is a non-citizen, this consent should not be given. Read that together with the provisions of section 65(1), Article 65(1) of the Constitution, and also Article 65(3)(a) of the Constitution, basically where the law outlaws the acquisition of an agricultural land by a non-citizen. Be careful that even under Article 65(3)(a) of the Constitution, a body corporate is to be regarded as citizen only if wholly owned by one or more citizens. So again, I know there is the practice where foreigners can form companies and use those companies to acquire land, but then again, somebody needs to look at the implications of Article 63, Sub-Article 3 very, very carefully. Under Section 9, Subsection 2, when application for the consent of the Land Control Board has been refused, then the agreement for a land control transaction will then become null and void. Now that is as far as the consent of the Land Control Board is concerned. We are saying that this applies in respect of controlled transactions, and controlled transactions are transactions based on agricultural land, and agricultural land is that land that is outside municipalities, outside towns. Now the other consent that would be required is the consent of the National Land Commission. Okay. Now this will arise in respect of all leases. All leases that are granted by the government are subject to certain conditions as to development and use. For this reason, there is a prohibition against transferring, letting, subletting, or even charging the leased property without the written consent of the National Land Commission on behalf of the government. Usually these provisions will be contained in the title under the special conditions, but then again, I also want to note that this requirement of the consent of the National Land Commission has been repealed by the Business Laws Amendment Act of 2020. And under the said amendments, the said consent is not a requirement for the transfer to be effected. But like I also, it's important to note that this particular requirement has been scrapped, absolutely. You do not require the consent of the National Land Commission for you to transfer your leasehold property. Another consent that I want to talk about, depending on the location of your land and depending on the use to which you intend to put this land. Typically, clients at the point of acquiring land, they have an idea on what they want to put their land into in the form of use. If the land is the one that is perhaps very close to the Kenya Railways, it is important that you may want to seek the consent of the Kenya Railways Corporation, again, depending on the use for which you want to put the land into. Certain uses will not be acceptable where the land is very close to the railways. Again, just like the Kenya Railways Corporation, consent of the Kenya Ports Authority, similarly, just like the Kenya Railways Corporation, if the land is the one that is located very close to ports or a harbor in Kenya, and again, depending on the use to which you intend to put this land into, it would be very critical that you may want to seek some form of consent, some form of authorization from the Kenya Ports Authority, because you might buy a piece of land, and then when you want to put that land into a particular use, you might find that the Kenya Ports Authority could object, especially if that particular use is one that would not be favorable, or would not be compatible, or would not be friendly to the Kenya Ports Authority. Consent of the Kenya Airports Authority might also be required, and where this consent could be required for any dealing in land that is bordering any airports or airstrips in Kenya, which fall under the jurisdiction of the Kenya Airports Authority. It's the same argument. If the land in question is one that perhaps is very close to an airport or an airstrip, and again, depending on the use, if you feel that the use that you want to put the land into is one that might require some kind of consideration from the Kenya Airports Authority, it would be important that you also get some form of consent, some form of clearance from the Kenya Airports Authority, because again, you might want to put this land into certain use and the Kenya Airports Authority could object, and you might then not be able to exploit your land as you would have wished to. It's important that you have got proper information, and it's important that you have some kind of alertness, especially when you are buying a piece of land that is close to an airport or an airstrip. Certain uses will not be desirable. Certain uses will not even be accepted when your land is very close or very adjacent to an airport or an airstrip. You might also require the consent of the chargee. If the property in question is the one that is the subject of a charge, which means the charge is registered on the title, you cannot be able to effect the transfer on that property unless the charge, or rather the consent of the chargee, is obtained. If the property is charged in favor of a bank, for instance, or is been charged in favor of a cooperative society, you must get the consent of the bank or the consent of the cooperative society before you can be able to effect the transfer, but otherwise such transfer will not be affected by the registrar. So we are saying that the charger must obtain the consent of the chargee before he can transfer or lease the charged property, which is the security of the chargee. This provision is contained in the charge or mortgage instrument. You do also want to look at the provision of Section 59 of the Land Registration Act 2012. Now, another consent that you need to obtain, remember these consents ought to be obtained by the vendor in conjunction with the advocates of the vendor. Consent of the lessor or the lessee. A tenant must always obtain the consent of the landlord if he wishes to assign his interest or sublet the property. Look at the provisions of Section 54(1) and 55 of the Land Registration Act. For the registered land leases, the consent of the lessee would also be required for any subdivision, transfer, or any other dealing. This has partly been captured when we are looking at the consent of the National Land Commission in relation to leasehold properties. But it can also happen that a person can lease a piece of land or even a portion of it. And those leases will also typically be registered against the title. It is not unusual, for example, to see communication masts on certain parcels of land, in as much as they occupy very small portions. The interests, that particular land on which that mast occupies will typically be protected by way of a lease agreement. And these leases will be registered against those titles. You cannot transfer that land to a third party without seeking the consent of the lessee. A good and a very classic example are the communication masts that you see of networks like Safaricom, networks like maybe Airtel, etc. The spaces on which those masts sit are leases, and they are secured by way of lease agreements, and they are typically also registered. And what that means is that you cannot transfer that land unless you have sought the consent of the lessee. Someone must also then be careful, especially when you have got a huge piece of land and you now want to lease out a very small portion of it. I don't know what they measure, maybe 40 by 40 or something. You can imagine if you want to lease out your property, your land is 5 acres, and you're about to lease out a small portion of it that measures 40 by 40 feet. The danger is that you will have locked the entire 5 acres if you do not administer that process very carefully. And once that 40 by 40 lease has been registered on that land, it will affect the entire title. You will not be able to even transact with the 5 acre land unless you seek the consent of the lessee. I would advise you that you first of all go through the process of subdividing. Perhaps you can have maybe a 50 by 100 subdivided out of the big piece of land, and then that 50 by 100 could be the one that you can give on a lease basis. If you do not do that, your entire acreage of 5 acres will be affected by that very small piece of land that you have leased out. And if you want to transfer that or even do anything, including subdivision, again, you must get the consent of the lessee. And then finally, I want to talk about the spousal consent. Now, Section 93, subsection 3 of the LRA requires the consent of a spouse where the other spouse seeks to charge or transfer a matrimonial land or a dwelling house, which that other spouse holds in his or her name individually. There are certain transfers that will require the consent of the spouse, where that particular land is registered individually in the name of the person who is seeking to transfer. And these are what are categorized as matrimonial land, or where the dwelling houses sit. If the matrimonial land or the dwelling house is on a title that is registered in the name of the husband, and the husband wants to transfer this land, then he must get the consent of the wife. If it's in the name of the wife, then he must get the consent of the husband. But I also want to clarify, it is not unusual, and it will not be unusual, to find that certain institutions will almost always insist on a spousal consent, regardless of whether the property is really matrimonial or a dwelling house. And institutions like banks, they will almost religiously insist on a spousal consent. And in fact, they will so insist on spousal consent to the extent that perhaps if you do not have a spouse, or if you're not married for that matter, then they might, or they will almost obviously require that you sign an affidavit declaring that you do not have a spouse, that you are not married. If you would want to escape issues to do with spousal consents, then it would then be required that maybe the land be registered in the names of the two spouses. Because if it's registered jointly in the names of the two spouses, then there is no consent that will be required of either party, because after all, their signatures or execution by both parties will naturally and automatically be a requirement. In conclusion, I want to say that the process of completion is a very important process in conveyancing. The conveyancing advocate must manage the process very carefully, and the clauses within which these processes are contained must also be constructed very, very carefully. The two twin clauses of consideration and completion must be constructed very carefully, because these two clauses, again, are the ones that will also inform the actual processes. I have explained that the complication that comes with the process of completion is the conflicting interests of the seller and the buyer. Typically, the seller would want the money for free. The buyer would also want the land for free. But on the other hand, the buyer, even if to part with money, would want the land very cheaply. And the seller, on the other hand, would want to sell his land very expensively. These conflicting interests is what usually make the process of completion a bit complex and has to be done very professionally and very carefully, because if that is not the case, then that is where we find a lot of disputes arising. And disputes typically will arise in the sense that the buyer has paid the money, but they have not obtained the land. The seller has transferred the land, but they have not gotten their money. The completion clauses and the consideration clauses must be done in such a manner, and the processes managed in such a manner as to ensure all the parties in the transaction at the end of the day get whatever it is that they have bargained for in the agreement. Professional undertakings play a huge role in protecting the conflicting interests of the parties, and even a huge role to ensure that the parties are not exposed. Whether it's a professional undertaking by the advocate of the purchaser, which is normally or typically to the effect that they are ready to receive the completion documents in exchange of a professional undertaking, and where the advocate undertakes that they will pay the balance of the purchase price upon the transfer of land in favor of the purchaser. Again, you can see the interests that are being protected in that scenario. The advocate must be careful before giving a professional undertaking, to the extent that the law actually requires that the advocate, at the time of giving a professional undertaking, the advocate should actually have that money in their custody in the advocate's client account. So that takes care of the danger of parting with money and yet not being able to transfer the land. Now, on the other hand, an undertaking from the advocate of the vendor, where the money has been paid in full, takes care of a scenario where money has been paid, but the land has not been transferred. Remember, the danger in that is, it requires that the advocate of the vendor holds this money as a stakeholder, and that he shall only release it to the seller upon formal advice by the advocate of the buyer. And that obviously will happen when the land is successfully transferred into the name of the buyer. That takes care of the danger that money has been paid to the advocate of the seller, money has been released to the vendor, and of course, once the money goes into the pockets of the vendor will certainly use the money. In the event that that particular transaction stalls, in the event that the purchaser is unable to transfer the land in his favor, we will have huge challenges of getting the money from the vendor, unless if that money is securely in custody or in the hands of the advocate of the vendor as a stakeholder. That is the end of our lesson. Thank you so much.
These televised lectures supplement our robust online learning going on our MKU online platform. You can view more on our televised lectures via our online platform. We are in a digital era, and Mount Kenya University knows this. The following are the steps to follow so as to complete your online application. Download the application form from the website www.mku.ac.ke. Attach copies of your academic certificates and ID. Pay the application fees via M-Pesa pay bill number 270988. Your ID is the account number. 2,000 shillings is the charge for a postgraduate. You can also deposit in the bank accounts provided on the website. Then email all the above to apply@mku.ac.ke.